Hello friends, in today's session we are going to discuss the case Shri M.P.Srivastava vs. Smt.Bina. Let's first understand this case in brief. The case pertains to section 47 and order 21 rule 2 of the CPC. The appellant and the respondent were married in 1958, but later the respondent left for her parental home. The appellant filed a suit for the restitution of conjugal rights, which was decreed in 1961. The respondent returned, but the appellant refused to accept her. The respondent then approached the court requesting that the decree be considered satisfied, and the court accepted her request. The appellant appealed to the High Court and later to the Supreme Court, arguing that there was an error in certifying the satisfaction of the decree. However, the Supreme Court observed that this argument had not been raised in the lower courts. It further held that under Order 21 Rule 2, a decree can only be considered satisfied if both parties mutually agree. Ultimately, the Supreme Court dismissed the appeal and established that new arguments cannot be raised in the Supreme Court if they were not previously presented in the lower courts. Additionally, Order 21 Rule 2 does not apply if there is no mutual consent between the parties. Now let's proceed with a detailed study of this case. Answer: Appellant Mr. M.P.Srivastava vs. Respondent Smt.Bina. Reference AIR 1967 SC 1193. Subject matter: this case is based on section 47 and order 21 rule 2 of the Code of Civil Procedure CPC. The case primarily focuses on the execution of decree and order and the disputes related to their execution. Facts of the case: 1. The appellant Mr. M.P.Srivastava and the respondent Mrs.Bina were married on July 25, 1958 under the Special Marriage Act 1954, Act number 43 I, and they had a child. 2. After some time, Smt.Bina left her husband's house and went to her parental home. 3. The appellant then filed a suit for the restitution of conjugal rights, claiming that the respondent had left him without any valid reason. The district judge decreed the suit on March 13, 1961. 4. The respondent wrote letter to the appellant expressing her desire to live with him as his wife. However, the appellant refused to accept those letters and returned them. 5. The appellant's family members tried to persuade him to bring the respondent back from her parental home, but their efforts failed. 6. Ultimately, on May 21, 1961, the respondent returned to the appellant's house on her own and started living with him. However, despite her repeated requests, the appellant showed no interest in restoring conjugal rights and failed to do so. Court's proceedings. Trial court. The respondent filed an application before the district judge Delhi requesting that the decree on March 13, 1961 be considered satisfied. The trial court accepted this application and passed an order certifying the decree as satisfied. High Court. The appellant appealed against the trial court decision before the Punjab High Court, but his appeal was dismissed. Subsequently, he filed a revision petition which was also dismissed. Supreme Court. After obtaining special leave, the appellant filed an appeal before the Supreme Court against the High Court decision. The following arguments were presented by the appellant. A. The trial court and the High Court erred in certifying the satisfaction of the decree because the actions of the respondent did not legally constitute the re-establishment of marital relation. B. The application filed by the respondent was not maintainable as the appellant had not filed any execution petition for enforcing the decree. Additionally, after passing the decree, the district judge could not pass any order unless the appellant filed an execution application for its enforcement. Opinion of the Honorable Judges. The Honorable Judges held that the first argument presented by the appellant was not raised before the district court or the high court. Order 21 Rule 2 of the CPC provides for the satisfaction of decree, which can be settled either by actual or symbolic agreement between the parties. However, if there is no agreement, this provision does not apply. Additionally, it was argued that if an execution application is pending, the other party may raise objection under section 47 of CPC. However, such an objection is only maintainable if an execution petition is pending. Under Order 21, Rule 2, an application can be filed even if no execution petition is pending, provided that the decree has been satisfied outside the court. Decision. Based on the above arguments, the appeal was dismissed with cost. Legal principle established in the case. In this case, the Supreme Court established the following legal principle. A. There is a difference in the procedure for filing application under section 47 and Order 21 Rule 2 of CPC. Section 47 deals with the power of the court, whereas Order 21 Rule 2 provides a limited procedure for recording the satisfaction of decree in certain cases. B. A question that has never been raised before the lower courts cannot be raised for the first time before the Supreme Court. C. The provisions of Order 21 Rule 2 does not apply if there is no mutual agreement between the parties. Please watch full video, share and subscribe to the channel. Thank you.